So what I will be talking about today is, I think, very different from what most papers or maybe all papers have been in this conference so far. It is quite theoretical, but also very practical. Theoretical because I have done it as a researcher, I have not practiced, but practical because it talks about the details of practice of how a case actually works in the WTO from a particular perspective. And that perspective is of the use of experts. Now, a lot of people here are, especially the panel chairs, are experts in international trade law. Now, I am not one of them, but I'd like to think that my expertise is on the topic that I'm going to talk about, and that is experts. Specifically today, experts used in WTO disputes. Now, here I want to make clear, since I mentioned legal experts, we are not talking about legal experts. What I'm talking about is scientific experts, and that is experts in, if you see WTO disputes, you have experts in any kind of topic, like diseases to apples, and like something as specific as that, and bird flu, and experts in all these kinds of niche scientific areas. And also at the same time, you have experts, economists you need very often in WTO disputes. So just to give a background, that's the kind of experts I'm talking about and how they are used in WTO disputes. Now, why is this important? This conference is about emerging trends, right? Now, the use of experts is not an emerging trend in WTO disputes. But if we look at it globally, in international dispute settlement as a whole, experts are being used more and more. They weren't used as much in the past, with the exception of the WTO. So I think the WTO is a good place from which other dispute settlement bodies can draw inspiration, can get guidance. And that is what I'm going to talk about in some detail, how experts are used on the WTO. It's not perfect though. There are some areas in which the WTO panels could also learn from other dispute settlement systems. So it's a give and take. Now, first, I just want to highlight a few rules, a few provisions of the WTO covered agreements which are relevant to this discussion to start off. First, of course, the Dispute Settlement Understanding, the DSU, Article 13, Paragraph 1, talks about the panel's right to seek information and technical advice from any individual or body that it deems appropriate. This is an important catch-all provision to keep in mind, because this is from where most of the time panels draw their right to appoint experts. Another provision, and this is in specific situations, is in the SPS agreement, the Agreement on Sanitary and Phytosanitary Measures. Article 11, Paragraph 2 of that agreement says, panels should seek advice from experts chosen in consultation with the parties in disputes involving scientific or technical issues, either in form of an expert group or by consulting relevant organizations, etc. So here the language is a bit different from the DSU. We should note that here the agreement says panels should. In the DSU, that talks about the panel's right to seek advice. And in fact, the appellate body has clarified in a case that is Japan Agricultural Products 2, that this provision of the SPS agreement, in fact, explicitly instructs panels to seek advice from experts. And why this is important is this may be one of the reasons that we see so much resort to the use of experts in WTO disputes as compared to other international bodies. We don't see this kind of language as in SPS Article 11 in other international treaties and statutes, for example, International Court of Justice or other such international judicial bodies. They always talk about there's an option for using experts, but it's not in such mandatory language as we see in the SPS agreement. Another important provision I want to highlight, and we'll come back to discussing that a bit later, is Article 8.1 of the DSU, from which we can clearly see that panelists need not be lawyers. They can be well-qualified governmental and or non-governmental individuals. This is important. I'll come back to it later. One last set of provisions I want to mention before discussing the actual practice is the rules of conduct. Now, these rules of conduct for the WTO DSU apply to, generally we think of course, the panel members, the lawyers, but it also applies to panel appointed experts. It should be noted only the experts that are appointed by panels, not other kinds of experts. And there, under these rules, experts are required to be independent and impartial and avoid any direct or indirect conflicts of interest. These are, of course, really important because when we are thinking of an expert, we want to make sure that that expert provides unbiased opinion and helps the panel in an independent and impartial manner. These requirements are also not something we see explicitly mentioned. We always expect that at the back of our minds. We always think, yes, this is an expert, it's an independent expert. Sometimes it's always used as a phrase, independent expert. But that's not always, there's no way of trying to at least guarantee that. And the rules of conduct in the WTO provide at least some way of doing that. And what they say is that these individuals, those who are appointed as experts by a panel, they need to disclose any interest, relationship, or matter that they could be reasonably expected to know that could give rise to justifiable doubts as to their independence or impartiality. So before their appointment is confirmed, they need to fill up a disclosure form and submit that, and parties get to look at it, and of course the panel gets to look at it as well. So this is one important way that, at least to an extent, the independence and impartiality of panel appointed experts can be ensured. Now, when we are done with the legal provisions, basic legal provisions, moving on to when, in what kind of cases experts are actually used by panels. Now, I keep emphasizing experts by panels because we will discuss a bit later, time permitting, other kinds of experts in the dispute settlement process. But right now, panel appointed experts, when do they come in? Of course, as I mentioned, SPS cases all the time, not all the time, almost all the time. Why not all the time? Because as it said, as Article 11 says, panels should seek expert advice. That is, in a case where a risk assessment has been done by a WTO member, and that is supposed to be based on scientific evidence, and the panel needs to assess that and needs help in assessing that scientific evidence. So in a case that's very rare, I think that as far as my knowledge goes, there's been one case, US poultry, where China was the complainant. The US had not conducted a risk assessment, and it did not contend that it had conducted risk assessment. So in that situation, of course, the panel will not appoint experts. Apart from that, in every SPS case, the panel has appointed experts. And in doing so, it has relied not only on Article 11 of the SPS agreement, but also on Article 13 of the DSU that I just mentioned earlier. And also, as that Article 13 says, you can appoint individual experts or an expert review group, but they have never appointed a group. It has always been individual experts, and appellate body has confirmed that, of course, the panel has a right to do that. And the reason behind the panel doing this is that they wanted individual opinions, that they wanted an expert's opinion to be his or her own, instead of having 3 or 4 people get together in a group and give one holistic opinion. They'd rather hear diverse opinions than one holistic opinion. Of course, the problem may arise that what happens if there are contradictory opinions? How will the panel decide between that? That is true. That problem hasn't come up yet, but their reason is that they don't want an expert to give up on his or her individual thinking and submit to the opinion of a group. Now, non-SPS cases also, there are reasons for appointing experts. There have been cases under the GATT. Why is that? Because the GATT, I guess most of you are aware of Article 20 of GATT. There's a General Agreement on Tariff and Trade. Article 20 gives certain exceptions where even though a member may have violated a provision of GATT, it can be justified because of protection of animal or plant or human life or health, or for an environmental exception, etc. So in these kind of situations, again, there might be scientific evidence. There's some real famous cases here, like the US shrimp case. And in the US shrimp case, in fact, the panel thought that it is, because there's a lot of evidence, scientific evidence submitted by the parties, some reports, expert reports, and the panel thought this is a good occasion when we can appoint experts to help us. And for this, of course, it can't rely on SPS agreement. It relied on Article 13 of the DSU. And there have been other cases like this as well. One of them is EC asbestos. But in some similar cases, again, we are out of the SPS realm. In SPS, they have always appointed experts. But in a case similar to, say, EC asbestos or US shrimp, for example, EC sardines, it was not a GATT case, it was a TBT case, Agreement on Technical Barriers to Trade. There were some labeling requirements on sardines. And there, the EC, in fact, requested the panel to consult an expert or an international organization, which could be an expert, but the panel refused. The panel did not want to appoint an expert. And here we need to go back to what the AB has said in an earlier case, that under Article 13 of the DSU, it's not mandatory. The panel has a right to seek expert advice. It does not have to. Even if a party wants, it does not have to. And thus the panels are free in cases where they want, non-SPS cases, free to decide not to use experts. And they have done that in cases where I think, and you can go back and look at these cases, where I think it would have been helpful to get expert opinion in deciding the case. Cases like EC seals, European Community seals, US clove cigarettes, and very recently, a very famous case, Australia plain packaging. These are all cases where the panel did not appoint experts. There was a lot of scientific and expert evidence submitted to it, but it decided on its own, or so it seems. Well, there it is. But we also need to go back to what I mentioned earlier, Article 8 of the DSU, that there's a lot of flexibility in terms of who can be appointed as a panelist. So the expertise could also be built into a panel. And in fact, in one case, Canada Patent Protection of Pharma Products, I think it's called, a medical professional was in fact appointed as a panelist. So it's possible, but some think that this is inappropriate because then this panelist could have an excessive control over the other panelists because they have this specialized knowledge, and then it's not equal decision making by all three members. So usually, very often you have non-lawyers as panelists. Very often they, of course, have a trade or economics background. A medical doctor is actually quite rare. But this is a possibility in WTO, which is not that common when you think of other international courts, standing courts like the International Court of Justice or the Tribunal for the Law of the Sea. They are all lawyers and former lawyers or judges from their countries. And in arbitrations, yes, you could always select and you can always decide what kind of a person you want as an arbitrator. But in these other international courts, unlike in WTO panels, you don't have the flexibility of appointing a specially experienced person as a judge, which you have in the WTO. Now, moving on to how they select experts, the expert selection process. Now, again, why I'm specifying and emphasizing on all this is because when in my research, I have compared this with other international courts as well. I keep coming back to the International Court of Justice, the Tribunal for the Law of the Sea, and a lot of international arbitrations as well. And this detailed process of expert selection, you don't find as you find in the WTO. So I'll just briefly go over how it happens. First of all, most importantly, there is extensive consultation with the parties, and it is very, very transparent. So they always think that they need to protect the due process rights and promote transparency. Also, if somebody could just tell me how long I'm taking. I haven't been keeping time. I know I'm supposed to speak for 20 minutes.
You can go on, no problem.
Okay. Thanks. Right. So there's extensive consultation with the parties to protect their due process rights and promote transparency. And the panels not only seek suggestions on whether to appoint experts in a particular case, but also on the areas of science in which advice may be required. So these are the issues in dispute. Do you want an expert on issue 1, issue 2, all of them? These are the kind of things the panel also asks the parties. It's not like, do you want, okay, let's do it, but they seek the advice. Finally, it's the panel's own decision. Another great source of advice is international organizations which are specific to that particular scientific issue. For example, WHO, World Health Organization, on, say, they haven't done it, but tobacco related issues. Or there are very specific organizations like Organization on Animal Health, and these kind of things, depending on the kind of issue. The International Convention on Plant Protection has a committee, so that when there are things related to apple diseases, for example. So they're very specific international organizations, and the panels often, very often, almost always go to them asking for advice on, okay, we have this issue in our case, can you suggest experts? So that is one very good method of expert selection, which I don't think is used or not used often outside the WTO. Then parties provide their opinions on these selections. So say you get a number of nominations from the international organizations, then the panel submits these names to the parties, and not just names, they have their CVs and detail, maybe even the disclosure forms at this stage, and then the parties are allowed to comment on what they think about this. Parties might come up with something that, okay, I don't like this about this one because of so and so reason, and finally the panel has all this material before it, and the panel takes the final call. So there's a lot of transparency in the process. Even the panel's decision, it gives a reason for its decision, especially because sometimes a panel may select an expert that one or both parties had objected to, and this happens. So then on appeal, if the case goes on appeal to the appellate body, there might be questions on whether the panel followed due process, and due process is really important. So the appellate body has emphasized that the selection of biased experts actually compromises a panel's ability to be independent. So the guarantee of fairness and impartiality and all of that is not there anymore. And that is why panels always give a detailed explanation of why they have selected or not selected this expert, even more so when there have been objections from one or more parties. Now, this is the method of selection, but then there's also the criteria, what goes behind the panel's thought process in selecting these particular experts. The most important factor, and this I found from, so if you read the panel reports and the documents connected to them, you have all the reasons. You have the the party's objections or party's reasons for objecting to another party's objections, the panel's reasoning, all of that is there. And what I find paramount is that the first most important thing in selecting an expert is, of course, its expertise, his or her expertise. So that is most important. I think it's more the case in WTO, the nature of disputes before the WTO, because they have very specific niche issues very often. It's not like climate change or something overarching. Like I said, diseases to apples in New Zealand, a very specific disease. And maybe that kind of disease is not even found all over the world. So you need people who are really expert on that topic. And then you have a problem that this one may be a national of this country, or there could be other reasons for which independence or impartiality may be in doubt. But what we have seen panels do is, of course, they try to take into consideration independence and impartiality as much as possible. But for them, the expertise is more important. Say we have only 2 experts worldwide on this topic. Then what can we do if they are also nationals of both the parties in dispute? They have always trumped expertise against a possible conflict of interest. Now, one way to try and get around this, and they have also done that very often, is consulting with international organizations again, because they work on this. They have people, not only their employees who work in the organization, but they constantly deal with people who work in that field, not just say diplomats or analysts, but also researchers, academics, all of that. So say you have at this moment, the panel has only 2 or 3 options. They could consider going back to an international organization to get, okay, a few other options who may be also expert enough, but also not giving rise to a chance of bias or a lack of independence, which may be the case with other experts. And we can also think that reputational concerns are likely to ensure that the experts remain generally unbiased and independent, at least consciously. Unconscious bias, of course, may always come up. And that is also often the case when you're talking about an international standard. Like often that is in dispute, that a particular international standard is, the interpretation of that standard is what has been in issue in the case. So you don't want to get experts from the organization that set that standard. And maybe those experts were, those individuals were involved in drafting that standard, and they themselves are interpreting it. So that may not be the best situation, right? Finally, the panel decides based on all these criteria and with a bit of consideration given to the parties' opinions as well. Now I want to move on to, once the experts have been selected, what happens in the written and oral procedures. This is also very important, because it's not about getting the best kind of expert possible, but also how you use them in the dispute settlement process. And this is again a very, I think, a very robust system that has been developed by WTO panels since 94 over the course of disputes. It's pretty consistent. They've changed maybe slightly and developed over time, but in the last several cases, they have been pretty consistent within themselves. So again, the important hallmark, this I'm stressing again and again, is the involvement of parties, because you don't want the parties to challenge any kind of opacity or not being transparent in any way. You don't want to challenge the panel for that. Then you go to the appellate body and then the case comes back and it's a waste of time. So party involvement is key at every stage of the process. Now, in the written proceedings, the appellate body has explained that this obligation to afford the protection of due process is not limited to the expert selection stage. And this is why this continues in the written proceedings. So parties can send their own written questions to the experts through the panel. So panel has questions for the experts, and then the parties can also send, of course, through the panel, questions of their own to the experts. But they can't comment on the panel questions in advance. This was actually earlier allowed, but in the interest of time, they have done away with this part. You can't comment on panel questions. Panel sends whatever questions it wants, but the parties can also send their questions through the panel. And then there's a further opportunity to comment on the expert responses to panel questions. And this kind of ensures a form of written cross-examination. You're all aware of cross-examination. It's common in almost all domestic jurisdictions. It's common in India. Cross-examination, just like you cross-examine witnesses, in this case, cross-examination of experts. Although when you think of cross-examination, you're talking about the other party's witness or expert. Here they are the courts or panel's experts, but the concept is the same. You want to be able to test what they are saying, and that is why cross-examination is so important. So in this written stage, we see a kind of written cross-examination where they get to question the responses from the experts. And in the interest of receiving independent opinions from each expert, the experts are not asked to, they're not even told who the other experts are, selected along with them, and they're asked to give their responses individually, and only later they are told who the other experts are and shown their answers altogether. Right? So in drafting the terms of reference for the experts and in carefully preparing the questions to be sent to them, panels also need to ensure that they're not delegating their judicial function. Because that is one problem people have very often with experts appointed by courts or panels, that and why they don't want experts appointed by courts in many jurisdictions is that we are submitting to the court's jurisdiction. This is the judge or these are the judges. We don't want someone else to decide. So what the panel needs to do here, it's something very simple. It's just that the questions to be framed need to be very carefully fact-based and only related to the expertise of the expert. And of course, they should not be legal questions. It's as simple as that. And now we come to the oral stage. Now that we have all the answers written down, there is a meeting with the panel, the experts, the parties delegation. And this is where it's a good time to mention the other kind of experts. Parties could also have experts on their own delegation. I'll discuss that in a little more detail later. But just to say now that all these people are involved in a meeting. This is usually between the first and second oral rounds, called first and second substantive meetings in the panel. Between these two meetings, you have an experts meeting. And here the experts are expected to answer the questions that they have received in advance from the parties and also other questions from the panel. The parties' experts here can also ask questions to the panel's experts or comment on their responses. Everything is recorded. There's a transcript made of all of this. And the panel's experts can also comment on each other's answers. So this transcript is really important because then everything is, again, we maintain transparency of all of this. And there's a sense of equality of the parties as well. So this is another stage where cross-examination kind of thing may be said to have occurred. We have the cross-examination at the written stage, which is kind of unique. And then you again have cross-examination, though not parties cross-examining each other, but cross-examining the panel's experts again at this stage. A lot of people have criticized this procedure as saying that you can't have an adversarial procedure with the experts of the panel, that is the court's experts, also called ex curia experts, because there's a fear that you antagonize them with the questions the way especially common law lawyers, cross question, cross examine. You can get quite aggressive, and if you do that, these are panel's experts, they get antagonized, they may say something against you, they may give an opinion against you, which is of course unfounded, because they are, first of all, you can ask your questions politely. The setting is not like a courtroom in a panel to begin with, and secondly, they are everything. There's a transcript. You see that it's not like legal arguments. You're giving scientific explanations. You've got data, and everything is fact based. So there is less of a chance of an expert that to an independent expert appointed by a panel suddenly getting swayed. So overall, this is how written and oral proceedings happen with panels experts. And I think this is a very robust, detailed procedure, giving, ensuring transparency and due process for the parties. Now, why I've emphasized this is, again, because this is not something we see to this extent in other international courts and tribunals. And the WTO, I think, is unique for the way it treats and handles panel appointed experts. And now I want to quickly move on to parties experts, which is where the WTO does not do such a great job. Am I running out of time? No? Okay. So parties experts, first of all, they're not recognized as a special entity, like party appointed expert. It's not a thing. You will find that a thing as an entity in all kinds of domestic jurisdictions and other international courts, but a party appointed expert is not recognized as such generally in WTO dispute settlement. But they are anyway included. Parties, if they need experts, whether in economics or in science, they want scientists, they include them on the delegation. And the appellate body has clarified in EC Bananas 3 that nothing in the DSU or any of the WTO agreements prevents a party from admitting any person it wants in its delegation. So nothing prevents them from doing this. And in context of, so this was of course in context of the appellate body, but even in the panel proceeding, this was confirmed in Indonesia Autos. That was about private lawyers arguing rather than government lawyers. But the broad wording, if you look at the wording of what the panel said in that case, it's clear that you can include experts as well. And if we look at the practice, that has actually happened, because in US Upland Cotton, where Brazil was the complainant, while noting the findings of the economist in that case, the panel said that it is open for a member to determine the composition of its own delegation for the purpose of WTO dispute settlement. And neither the DSU or the agreement on subsidies, which was an issue in this case, contains any specific rules on any sort of qualifications of experts. So, and this is important, the panel underlined in this case that they considered the participation of experts as part of the submissions of the parties, and third parties contributed constructively to its duty to conduct an objective assessment. So they have called them parties experts, they've recognized them as an entity, although nothing in the WTO rules and procedures ever recognizes such an entity. But by their silence, they have been quietly included. And I think they are a really important aspect as well, because you can't always just rely on panels experts. And as we have seen, sometimes where there's been a lot of a need for expert opinion, expert advice, panels have not appointed experts, and the only expert opinion scientific evidence we've had has come from parties experts. So the fact that they have been allowed in through a back door is very important. And we find that party appointed experts are recognized and are really important in other kinds of, when you have scientific issues in other international judicial forums, but not so in WTO. But we have actually seen scientists as well in delegations in WTO disputes, like in the EC hormones case. And they can provide advice to the parties behind the scenes, or they can prepare independent reports that the parties can include in their submissions. And also they are present at panel hearings. And here I go back to what I said earlier. They're also present at the expert meetings, and they can also question panel's experts if the panel has appointed experts in that case. Now, there is no provision, since of course there's no provision for a parties expert, there's no provision for cross-examining a parties expert. And this is missing, because we have cross-examination even of a panel expert, but that's not there for a parties expert. But in an ad hoc way, this seems to have happened. Now, I'll just come back to that. Even in one more case, I want to mention Japan agricultural products too. The panel noted that parties are free to include in their delegations scientific experts of their own nationality, and they can also submit scientific evidence produced by their own nationals. Now, here too, we must remember, even though there is no particular recognition of this entity, we must remember that parties' experts must appear to be independent and credible. That is the only way their evidence would have any value. If they are seen as counsel and arguing rather than presenting facts, then what's the point of having an expert, right? You see in a famous case in the International Court of Justice, the pulp mills case, the court had said that we don't want experts arguing as counsel. What's the point? They need to be cross-examined. And I think that's a really important takeaway for the WTO, because even though parties experts have been quietly recognized, well, not explicitly, but implicitly recognized in so many disputes, they are not cross-examined. However, panelists do sometimes ask questions to those who are presenting a part of the case from a party's delegation. And this could be considered as a kind of cross-examination. Of course, panelists asking questions. The cross-examination, you would expect the other party, the other side to ask questions. However, a lot of counsel, people who lawyers who regularly appear before WTO panels have said that this, and they are common law lawyers, so they are used to cross-examination. They have said that this kind of questioning, to an extent, makes up for cross-examination, in their opinion. So I think it's high time that these parties' experts are recognized as a real entity in WTO dispute settlement, and so then they can be subject to cross-examination. And there are so many processes. I mean, it's clear that WTO panels know how to deal with experts because they have such lovely detailed procedures in terms of panel-appointed experts. And the same should happen for parties' experts as well, especially in cases where the panel has no experts and we just have experts from the parties, and that would really help in deciding the case and really help the panel in assessing the evidence when it doesn't have experts of its own to help it. So here I just wanted to highlight the use of scientific experts in WTO. We've seen that there are pros and cons. They do a great job when they do appoint panels experts, but there's still a lot remains to be done in terms of parties experts. And there's so much more I could have said. As you know, it's a part of my thesis, so I can talk about this for an hour. But I really am looking forward to hearing the papers of the presenters today. So we will move on to that.